Thank you so much for being here. Thank you, Wilma, for making all of this happen. Thank you deeply to our very distinguished panelists, and thanks to all of you for being part of this conversation. My name's Josh Edelson. I cover labor in the workplace for Bloomberg News and our magazine Business Week, and I would love to hear from any of you in the weeks and months and years ahead. And I look forward to everyone's participation in this conversation. Please feel free to share questions at any time in the chat. One of the paradoxes of the New Deal's National Labor Relations Act is that it makes expansive promises about workers' rights, but gives the federal government severely limited tools to enforce them, and then restricts states from trying to enforce those rights themselves. Despite those limitations, with federal labor law reform efforts stalled, in recent years, we've seen elected officials and labor leaders increasingly look to what state and local governments can still do on their own. In recent weeks, for example, we've seen a New York court rule that the state attorney general's lawsuit against Amazon involving alleged retaliation was preempted by federal law. And we've seen the Connecticut legislature pass a law targeting captive audience meetings, which is likely to set off its own legal challenges. To discuss the prospects and challenges of state action to address worker voice, I'm joined by a superstar panel. You can read their full bios online, but in very brief, Kate Andreas was Chief of Staff in President Obama's White House Counsel's Office and is a labor law professor at Columbia. Jessica Ramos is a New York State Senator and chairs the Senate Labor Committee. And Mary Joyce Carlson is a former Deputy General Counsel for the National Labor Relations Board and the top lawyer for the Fight for 15. Thank you very much again to our panelists. And Kate, please kick us off.
Great. Thank you for having me, and thank you for organizing this, Josh, and thank you to Lyra. So I know many of the names in the audience, and I know you're all very well aware of the extent to which federal labor law has for many years failed to achieve its basic purposes of providing workers a voice in the workplace, improving wages and benefits, equalizing bargaining power, decreasing economic inequality. So we're all well familiar with those failures. One promising development is that in recent months, we've seen the NLRB, the agency, working in really innovative ways to try to breathe new life into the NLRA to address some of the problems with the statute. But as we know, anything achieved by the NLRB can easily be rolled back by a future administration. And moreover, many of the problems are really baked into the statute. I think probably most of us agree that fundamental labor law reform is needed, but at the same time, it is unlikely to occur anytime in the near future. This dynamic has led to what a number of scholars have called an ossification of federal labor law. But in fact, as Josh mentioned in his opening, there's actually a tremendous amount of innovation occurring at the state and local level. So I thought just to start us off, what I would do is say a few words about the legal framework that governs what states and localities can do, and then outline a few of the major categories of reform that are ongoing. And then Mary Joyce and Jessica, Senator Ramos, I'm sure we'll have more to say about kind of the details of that. So I just wanted to give an overview to start us off. But labor law preemption doctrine is very strong. Garmin preemption prohibits states from regulating any activity that is protected or prohibited or arguably protected or prohibited by the NLRA. Machinist preemption prohibits states from regulating activity that Congress intentionally left unregulated, or that the courts deem that Congress intentionally left unregulated. And in addition, if a state law claim is dependent on any analysis of the terms of a collective bargaining agreement, then it is also preempted. So as a result of these essentially like three major labor law preemption doctrines, states are largely unable to pass legislation that directly governs organizing and bargaining rights for most private sector employees. But there are a few really important ways in which state and local law is not preempted. First, federal law doesn't preempt states and localities from enacting employment legislation. So they can pass general employment standards like minimum wages and scheduling laws. But even more important, I think they can do so in ways that allow worker organizations and employers to participate in designing standards for their own industries. So through passing employment law, states and localities can create a form of sectoral standard setting. Second, federal law allows states and localities to establish organizing, bargaining, and strike rights for industries that are excluded from the NLRA, so domestic work, agricultural work, public sector work, and possibly for gig work, although there are some questions about the extent to which federal law, including antitrust law, preempts such efforts, and we can talk about those. But then third, federal law provides states and localities room to make decisions about labor relations when governments are acting as market participants. So when they're purchasing services or spending money on contracts. Also, it allows, there's a lot of room for state action, obviously, when it comes to right to work, which is a different subject. But given those three buckets of areas in which the states can regulate and can regulate in ways that are beneficial to workers, really important innovation is occurring at the state and local level on all three of those dimensions. So I want to just highlight a few of the sort of general ways in which that's happening. First, many progressive states and cities are working to pass new employment legislation that is really raising standards in important ways and changing the baseline against which workers can organize and bargain. And several of these new efforts involve worker participation in new ways. So worker standard boards, which are also sometimes known as industry committees or wage boards, where the relevant Department of Labor brings together workers, employers, and the public in some way to address problems in a particular industry and to set standards for that industry. Another notable and somewhat new development is that a few localities have recently passed just cause legislation. So another way that there can be universal legislation to change the background against which workers are organizing. Second, a number of states and localities are working to extend labor rights to workers long excluded from labor protections. Just some notable examples there, developments around agricultural work in New York, and then domestic worker bills of rights and protections in a large number of states and several cities. And then third, there's a lot of new experimentation with using the market participant rule. So states and localities insisting that public contracts require employers to commit to labor peace, to fair working conditions, and so on. So with that, just kind of setting up the main categories, I will pass that over. Thank you.
Thank you very much. Senator Ramos?
Thank you, Josh. Thank you so much for including me in such an esteemed panel today. Well, greetings to everyone from Albany. We're actually on our last day of our legislative session here. And there's a lot we got done this session. And of course, there is a lot more to do. But to tell you a little bit more about myself, I largely see my job as chair of the Labor Committee within the light of finding gaps and loopholes that employers use to cut corners on safety and close them, of course. I look to strengthen protections for workers that are not covered by a union yet. And of course, I aim to clear a path for any worker who wants to join a union. Those are really the three tenets of my duties here as chair of the Labor Committee in New York at what I think is quite a critical juncture. I think about work quite a bit. I think we work too much. I think we work too hard. I think we don't spend enough time with our families. I don't think we have enough time to sleep and to take care of our health. And all of those things, of course, are necessary to a human being's good quality of life. I come from the labor movement. I worked at SSEU Local 371, New York City Social Workers Union for many, many years. And I worked at 32BJ, SEIU for many years, where my last project was Build Up NYC with the Building Trades and the Hotel Trades Council. And I learned a lot from those endeavors in figuring out exactly where the most dangerous work has been and what it is what measures we can take, what initiative we can take in lieu of the lack of action at the federal level here in New York State. And well, starting with my freshman year here in the Senate back in 2019, we passed the Farm Worker Fair Labor Practices Act, which Kate had mentioned earlier very briefly. You know, before 2019, farm workers in New York State did not have the right to a day off, did not have the right to unemployment and disability benefits, or the right to have a voice on the job, much less overtime pay. And we were able to win those things, establish a wage board to figure out how we could walk back overtime from 60 hours to 40 hours, like every other worker in New York State. And we have been very successful in legislating for them. I'm very proud of what we've been able to do there. And then just yesterday, I'm actually very sad that Lorena Gonzalez couldn't be here with us today, because she's been such an inspiration for me all the way from California. I've looked up to her for a very long time. Yesterday, we passed the Warehouse Worker Protection Act, which is a bill that will protect warehouse workers, warehouses that have at least 100 employees, where these companies are now using very mysterious algorithms that dictate how hard, how fast they need to work in order to meet the company's quotas. And this, of course, is most prevalent at Amazon, but also at other employers, at other workplaces like UPS and FedEx, to name a few. I've also introduced, and I'm hoping to pass it next session, our Nail Salon Minimum Standards Council Act. It's a bill that I'm suggesting in order to create a space here in state government for nail salon workers and nail salon owners to be able to come together and negotiate for better wages and working conditions. It's a very particular industry because it's hard for workers to organize from shop to shop. And, you know, these nail salons are very often owned by immigrants themselves. And so we want to make sure that we are helping the workers who are, you know, victims of wage theft, rampant wage theft, and exposed to very dangerous chemicals that have affected pregnancies and caused many other diseases. We want to make sure that we're providing a very safe workspace for them. And then, of course, I'm also on a quest to ban captive audience meetings in New York State. I feel very passionate about this bill because unfortunately, many corporations use captive audience meetings, meaning that they take workers off the work, you know, off their workspace, put them into a conference room, show them anti-union propaganda. They get speeches from anti-union law firms and PR firms in order to dissuade them from joining a union. And quite frankly, that is, and it's really unfair when these companies use their money so poorly, when they can actually be using those funds towards improving safety and certainly giving workers the wage increases that they deserve. So that's really just a little taste of me and of what we've been working here in New York. Quite frankly, it's a lot. I think we're at a critical juncture after the pandemic. I think we're never going to have a moment like this one again, where nearly every single person really realize that they are indeed a worker. And we're very aware of what protections they did and did not have. For example, here in New York State, many people, despite being documented, realize that they don't qualify for unemployment insurance. And so even though there was PUA during the pandemic, now it doesn't exist anymore. And they have joined the ranks of many other New Yorkers, including undocumented New Yorkers who also don't qualify for unemployment insurance despite paying their taxes. And so during the pandemic, we created the Excluded Workers Fund. It was $2.1 billion towards all of these workers who are mainly paid in cash. And now we're in pursuit of a permanent solution, a bill called Excluded No More, in order to create a state unemployment insurance system that fills the gaps left by the federal system, because it just hasn't been able to catch up with how work is actually happening in our society today. So Josh, thank you for having me. I'm very happy to be here and even happier to answer any questions.
Thank you very much. Mary Joyce? You're on mute, Mary Joyce.
Thank you. I'm very happy to be here. As Josh said, I have counseled the movement known as the Fight for 15 movement for some 10 to 12 odd years. And while the movement has enjoyed great success, has been led by fast food workers and has enjoyed great success in raising the floor of a minimum wage, the workers themselves have not successfully gained a voice at their workplace. And nowhere was that the failure of that more evident and the need for it more evident than during COVID. Because fast food workers were declared essential during COVID, they were, because of the conditions in their work site, the fact that they're crowded in small kitchens, that they're in touch with the public, that they're crowded at the counter. There were significant COVID outbreaks among these workers. And they also worked in an environment where I think there's a California study that shows that fast food workers, employers never implemented any or very few of the recommended policies or procedures for protection. So I'm going to talk a little bit about California, the other end of the state, and then I'm going to talk a little bit about the places where we have little possibilities of having innovative state action. So in California, there are 550,000 fast food workers. There's the largest number of those workers in California than in any other state. And we were very active in organizing during the pandemic. I think that we started out filing with state agencies. We moved to OSHA. I think we filed as many as 200 health and safety complaints out of the fast food industry. We filed a lawsuit trying to get changes in the franchisee that was called the doggy diaper franchisee. That's how it was popularly known, because he actually used doggy diapers to create personal protective equipment in his shop. And so we used a public nuisance theory to file a lawsuit there. I think more than 2,500 workers conducted health and safety strikes in California during the pandemic. We protested, we lobbied, we did everything we knew how to do. And what we finally did is we introduced a piece of legislation, which is now called the Fast Recovery Act. And it's now passed the California Assembly. It will be, there will begin hearings in the Senate, the California Senate, on January 8th. And on January 9th, there will be more strikes, and there will be civil disobedience that will be conducted by the workers and their allies in California. What this bill would do, its purpose is to establish a sectoral council in the fast food industry in California that would be made up of employers, including franchisors, franchisees. A lot of the fast food industry is, in fact, the majority of it, I would say, is a franchised industry. Government agencies, including the health agency, the labor agency, representatives from those agencies, workers and their representatives would all sit at this council and would develop standards around training, around wages, around health and safety. And those standards would then be reviewed by the California State Legislature. And if the review, following the review, the standards would be implemented. So this is really, it's an incredibly important initiative for the Fight for 15, because it's an attempt to raise standards for an entire sector in one state, that is the fast food sector. We're very optimistic that this will pass the Senate, and we're hopeful that the governor will sign it into law. So that is the biggest and I would say most significant of the initiatives that the Fight for 15 has been involved in, although there are others that are also interesting. In Nevada, for example, the Nevada legislature has established a home care workers council that covers home care workers, that again is made up of state representatives, and the home care employers, home care workers themselves, and consumers of home care. And the first standard that that council has set has been a training standard for all of home care workers. The standards are recommendations, and the training standard was accepted by the state. And so training has begun with home care workers there. There's also an advisory council that's been set up in the city of Detroit, and that for nursing homes. And that council can be initiated by the mayor. It can be initiated by employees. And there is a petition among nursing home employees right now seeking to operationalize the council. I think that that petition requires the signature of 200 workers in the industry. And then that council will also be active, again, in only an advisory capacity. And I would say that for the advisory capacity, and even for this initiative that gets written about in California, none of this would come about but for worker militancy and activity. And it just, that is the baseline. It's grassroots activism. That's how we move any of this. And it's why the campaigners, the organizers, the unions, the workers, it's why they're embracing an idea, taking to it and working for it is the way that we get any of these innovative reforms. And you have to have political power. And so SEIU, the Fight for 15, there's quite a bit of political power in the state of California. 32BJ has quite a bit of political power in the state of New York. But what happens in Texas, Florida, Georgia, Missouri, Arizona, New Mexico, Oklahoma, Kansas? What happens in all those, Kentucky, Tennessee? What happens to workers in all those states where you're not going to get the state government to agree to any of this? You will have grassroots activism. Those workers are just as willing to strike, protest, and be active as any, but they're without some of the tools that you rely on in a state where labor has a lot of political power. And so I actually think the challenge in this area is it's just as great for the parts of the country where labor has less power, the protection of workers, the organizing of workers, the building of power among workers. That, I think, is a huge challenge for the labor movement and for the progressive movement in this country. And we can be heartened by the fact that, for example, labor united in Houston, Texas, to get Houston to create a standards council that I think was largely led by the building trades there, who are the strongest of the labor groups in Texas. But, you know, so that's what, and I think about this because I think about it in the context of the National Labor Relations Act, which I agree is ossified, flawed, et cetera, but in a state like the ones I just mentioned, workers who organize and who are retaliated against for organizing, what do they have to protect them? They have their own self-organization. For example, in the Fight for 15, we developed this mechanism known as the walk back. And so we would gather the religious community, we would gather other labor unions, we would gather other allies. And when workers struck, all of those people would go and walk them back together in hopes that we would restrain retaliation. And the National Labor Relations Act is the law that, at least on paper, affords the right, and the challenge is to make that law work when workers organize and are retaliated in those states. But workers, you know, it's very interesting. The Starbucks workers are on the move now. And recently, elections, there have been strikes in Columbia, South Carolina, elections have been won in Anderson, South Carolina, labor board elections by very large margins, and in other parts of the South. So the issue there is, will federal labor law, which is what we've got to work with, will it be able to protect those workers from retaliation? And will, the organized efforts and, and the law itself actually support bargaining and the institution of power among the workers? So I think it's great. I always have to remind myself that before healthcare workers had the right to organize federally, the state of Wisconsin provided the right to organize for healthcare workers. And it was an important early model. And so hopefully these experiments and these models that are happening now will be important early models that will be expanded nationally. But, and it's good that they're happening where they're happening. Like that New York wage board for fast food workers it was a great thing when it raised the wages, because eventually those wages were expanded all over the state of New York for the public sector workers, the universities, et cetera, et cetera. But there were no wage board. I mean, that was sui generis. We hoped it would spread, but it turned out to be sui generis to New York. So I leave you with that. In my mind, our big challenge is to innovate where we can innovate, but protect and build where there's very little possibility of innovating.
Thank you each very much. And please, anyone with a question, share it in the chat. In the meantime, one issue I think is interesting that Senator Ramos and others have brought up is captive audience meetings. And here, there are interesting split screen events going on in that you have an existing NLRB precedent allowing companies under federal law to conduct these mandatory meetings. You have an NLRB general counsel now who's taken the position that those meetings violate the act, that they're inherently coercive. And then you have states taking the position through legislation that they can legislate on this themselves. And so I wonder, particularly, Kate, if you have a thought about whether the activity on the NLRB end that we're seeing now makes any difference in terms of whether state legislation would be seen to be preempted, or in general, how safe or risky an area this is. And also, Senator Ramos, how you weigh in wading into an area like captive audience meetings, what the level of risk of ending up on the wrong end of a federal court case might be, and how that enters the calculation.
Sure. So I think that employers are likely to make the argument that captive audience legislation, we know they will make the argument that any legislation prohibiting captive audience meetings is preempted by the NLRA, whether the general counsel reverses position or not. And the argument would be, I think the argument is basically twofold. One is that the act does regulate, it does protect employer speech, or it arguably protects employer speech, and it regulates in many ways what employers can say and what they can't say. Or alternatively, under machinists, that the act intends to leave that open to kind of market forces, right, employer power, and therefore anything regulating captive audience meetings is preempted. I think they're also likely to make freedom, First Amendment arguments. And one of the concerning things about what we see happening in a lot of these cases is novel constitutional arguments being raised by the Chamber of Commerce and by business groups, which are really specious under current doctrine, but could well get taken up by conservative courts. So that's what employers are likely to argue. When the bills are well designed, they are not specific to labor captive audience meetings. They're general minimum universal employment standards that govern kind of rights at work generally. And so there is, I think, the best reading of the doctrine would find them not to be preempted, but I wouldn't want to necessarily take a bet on what would happen before a federal court on those issues. That said, and I'd be interested to hear what Senator Ramos and Mary Joyce have to say on this, but I think that it's not really the job of, the worry about what a conservative court might do with legislation should not necessarily constrain the aspirations or efforts, particularly when legislation can be designed in such a way that it's defensible. So the power that employers have to hold coercive meetings is outrageous, and to the extent that states have the political power to change that, or there's political will to object to that, I think that's important, even if there's some risk, litigation risk, that a conservative court will find it to be preempted. Obviously, if the general counsel concludes that the act prohibits captive audience meetings because they're coercive and therefore violate 8A1, there's less need for the state legislation. But I think the employer arguments on preemption are likely to be the same either way.
Well, I couldn't agree with, Kate pretty much covered everything. That's exactly what we're trying to do in New York, is get around by covering not just, worker meetings, but really get to the tactics that a lot of these companies are utilizing nowadays. And quite frankly, if the federal government is not going to take action, then I do believe that we as states need to take on that risk of protecting our people, designing legislation, getting legislation passed. And if it's going to be challenged, then so be it. We're up for that challenge because the price to pay is way too high. We want our workers to feel compelled to join unions, and for companies not to coerce them into these meetings, subjecting them into unwanted propaganda, and especially doing it on company time when we know that union organizers are not really allowed. And now Amazon's a great example, of course, for many of these, has now developed an app that can rule out many of the words that workers cannot use between them. So I think it's been difficult to create the political will. I've now carried the bill for a few years. Many labor unions are, of course, on board, but also many people don't understand what captive audience meetings are, and the conversation with rank and file workers who I need calling their legislators, who I need mobilizing towards these, against these tactics, I should say, and for the legislation, has been a little more nuanced than I would like. And I'm hoping that next year, given all of the headway we've made with Amazon and many other employers and many other industries, that we'll finally be able to get our message heard.
Thank you. Peter asks a question about the breadth of legislation and whether there are political risks in cities or states over-promising and under-delivering on new worker protections. In particular, he asks, how would you weigh trade-offs between targeted measures that could be easier to enforce versus broader protections that cover as many workers as possible? Would anyone like to speak to that? Please.
Sure. Thanks for the question, Peter. My approach is to introduce as many bills as possible. And many of them are specific to industries, specific to a workforce. But some of them are much more encompassing of a greater labor movement. And my aim is to bombard the legislature with as many pro-worker bills as possible in order to get to see which ones stick and which ones I can create the political will for. I refuse to be daunted. I refuse to be scared of what the backlash might be. I've now been a senator for 4 years. I've been chairing the labor committee for that time, and I think that has actually helped workers feel like they have more of a voice in government than ever before.
I would just add, I think the political calculations vary depending on the state. And but one interesting thing about one of the bills that Senator Ramos mentioned, the nail salon bill, it's one that is specific to a particular industry. And what that means in that context is that the bill is able to be targeted in such a way that it really addresses the particular problems of that industry, including, as Senator Ramos mentioned, by enabling employers to be at the table and to actually address problems like the downward pressure on prices in that industry. So I think sometimes there are good arguments from a policy matter why things need to be specific to industry. But obviously the goal for those of us who support workers' rights is to make, you know, the broadest coverage and strongest coverage possible. But sometimes there are industry-specific issues that I think favor more targeted legislation, aside from political considerations.
Thank you. Steve Greenhouse asks, given the spectacular success of NLRB elections at Starbucks, whether it's time to try large-scale similar efforts at fast food companies like McDonald's, Chipotle, Taco Bell, which, as Mary Joyce noted, the past Fight for 15 campaign has targeted in other ways. Steve says, don't you think that many of the low-wage workers there, often immigrant workers, often workers of color, would be enthusiastic about unionizing? He notes that the legislation in California, he says, seems excellent, but he's wondering whether formal unionization could be pushed in tandem. I would, to broaden the question out a little, just add this question of, are there ways in which the legislation that SEIU has pushed in the employment area or the wage board area at the state level create riper conditions for winning NLRB elections or winning recognition in the future in some way? And Steve directed his question to Mary Joyce to the extent that she's willing to answer it. And I'd, of course, also be interested in any thoughts that Kate or Senator Ramos have as well.
Well, the Starbucks votes are really inspiring. And one thing I would note about Starbucks is that it is not a franchised company. So when you join together with your other partners, your compañeros across the country to vote for a collective bargaining agreement, to vote for unionization, you've got one target. You've got Mr. Howard Schwartz and Starbucks. And that's a very different situation with actually most of the fast food restaurants, even ones that are local like Jack in the Box or In-N-Out Burger. The fast food restaurants I think they figured out that you provide a brand, and you know, McDonald's is the best on this. You regulate the supplies, you regulate what can be purchased, you regulate hundreds of things, but you still operate through a separate business entity. And that frankly makes it makes organizing a bit more difficult, or it makes, let's say this, it makes a vote more of a challenge, or because who's the employer? You know, we fought that joint employer case, hoping that we would establish that McDonald's was in fact a joint employer. Maybe we could do it again through in our case. Do I think these workers would vote? Yes, absolutely, they would vote if that were what would achieve unionization for them. But it's really unclear to me that that's a path that would lead to unionization for them. And as far as the legislation goes, what we're really hoping is that will lead to unionization. That if this council is established and there can be a practice and an experiment of employers, government, and workers sitting down together, working on health and safety problems, working on training problems, working on the problems at the work site, that is going to make it much easier to achieve unionization in the industry in the long haul. And by the way, as inspiring and wonderful as the votes are in Starbucks, and I think they'll continue, I think those votes will continue. I don't think they're going to stop. That is different than there's still, as you know, Steve, there's a couple of more steps you got to get to achieve a union. to have a union that has a contract. So this is obviously the first thing is going spectacularly. The first part of it is going spectacularly, and we're hoping that, you know, there will be enough power in that that the Starbucks workers will get to where they need to go. But it's just a different company. And I think there's a temptation to say, well, why not this now? And the same calculations that existed at the beginning of the organizing drive, I think for McDonald's, you still have to, it's still a calculation.
Thank you. I'll raise another hot button issue in this area, which Kate alluded to, which is this question of workers whose status under federal labor law is contested, like so-called gig workers, where people disagree about whether these are employees or independent contractors or not. We have seen a number of fights in California, in Washington State, in Connecticut, in New York about different models for the state creating some set of protections and or some set of protections for companies against liability. And so I'm interested in any thoughts any of our three panelists have about what the right approach is here, and in particular as well, how what the state does might or might not affect what the NLRB does in thinking about these same set of workers.
Okay, well, that's a very contentious topic here in New York State, as many of you know. Last year, the Independent Drivers Guild tried to introduce an 11th hour bill called the Right to Bargain Bill that really relegated Uber and Lyft drivers to being second-class workers in New York State, taking away their right to strike, slashing their pay, taking away a few benefits, but actually giving them others. And as many of you might know, here in New York State, Uber and Lyft drivers or for hire vehicle drivers were able to obtain unemployment insurance throughout the pandemic, thanks to a court order just before the pandemic took place, actually. And we here are still waiting for Uber and Lyft to contribute to our unemployment insurance fund. And quite frankly, you know, our financial solvency might not even be as strong if, heaven forbid, we were to enter another period of such calamity where we're supporting all of these workers, and yet some of our biggest employers are not paying into the fund. So this is something that I've been trying to pursue, but quite frankly, I'll be very honest, I have failed to find who can help me tabulate exactly how much money it is that these employers owe us. And I of course, suspect that it's not just Uber and Lyft who fall under this category. But the bigger question of classification is one that we're trying to address here in New York. I am yet to introduce legislation specific to that industry, but I'm hoping to do so soon, perhaps even as soon as next session, certainly granting them a lot of the same rights without creating a second tier of workers, you know, because these do happen, especially here in New York, they do happen to be mostly men, mostly immigrant men, mostly men of color. And so taking away their right to strike, taking away many of the other rights that other union employees enjoy would not be right. But there is the issue, sincerely, that many drivers really do believe that they own their own business and that they are independent contractors. And for them, they really believe that this is the only way to protect their flexibility in scheduling. That's the number one reason that I hear why a driver does not want to be classified as a worker. And I think, you know, it's not thinking outside of the box here in how we can actually protect the ability for workers to establish their own schedules, but certainly gaining the same rights, especially when an app is telling you where to go, who to pick up, right? And the indications clearly that these companies are employers and not just mere rideshare applications connecting so-called independent contractors. I mean, there's that. There's many other apps, of course, like Instacart, where people are shoppers and they go shop for someone at a supermarket. But if they fall at that supermarket, you know, is it workman's comp? Is it, or are they going to be able to sue the company? There are so many questions around how this work is being done. But I also do want to point out that a lot of this discussion is kind of being shielded by the conversation about the deliveristas, who cannot be classified as employees because they are mostly undocumented workers. And unfortunately, and this is something that I feel very strongly about and also have a bill to address, the federal E-Verify program is of grave danger to many workers and puts workers at risk in many of their workplaces, unable to be hired by better employers, by better contractors and developers if they're in the construction industry. And, you know, as of right now, you know, many of them don't have work permits in order to be working for a lot of these apps like DoorDash and the like. So it's a very sensitive topic. We want to make sure that we are taking into account all of these different situations. But I am hoping to begin to tackle this area come next session. So stay tuned for January.
If no one else wants to weigh in right now on that one, while we wait to see if there are more questions from the collective, I'll ask about where we see this going over the next decade, say. I mean, on the one hand, are some of these laws in a position to spread to a bunch of states? And on the other hand, is this something that is going to be getting more attention in the federal courts? I mean, we saw, for example, the Supreme Court choose not to take up a case around these questions of the state government's authority as a market participant to wade into areas like requiring labor harmony. Certainly, historically, tactics that have been very effective for organized labor tend to come under scrutiny in the federal courts and at the Supreme Court. So where do we see things going on the one hand in terms of labor groups and labor-backed legislators pushing some of these boundaries, and on the other hand, is this something that the Supreme Court is going to be doing more to hem in?
I can start. I'd be interested to hear about from the organizing and legislative side where things are likely to be going. But I'd say I think I see three really exciting things happening right now and converging in a very exciting way. One is the upsurge in grassroots activity and organized activity among workers. And that's certainly the most important, because none of the legislative changes will really come to much without an upsurge of organizing activity. And we see that both in terms of the new organizing drives, including among Starbucks workers, but also the increased organization and militancy among workers who have been organized for a long time. So the teachers' strikes or manufacturing worker strikes, and there is a significant uptick in the amount of organizational activity among workers in a way that is really exciting. That combined with the innovative work occurring in some jurisdictions, and we've highlighted the work in places like excuse me, California and New York, but there also, you know, has been, as Mary Joyce mentioned, there's been a lot of successful work also in red states, and the ballot initiatives to raise the minimum wage really were thought, you know, unthinkable a decade ago, and were very successful, including in states where at the same time as Trump won. So there's actually widespread support among voters for these kinds of policies. So organizing activities, state and local innovation, and then I think the work that's being done at the NLRA is truly exciting and innovative and really could help support both of these other trends. Now, what happens to all of that at the courts depends a lot on who's on the courts. President Biden has had a lot of success in appointing really great progressive judges who've had careers as public interest lawyers, and even one who was an 1199 organizer, who's now on the Ninth Circuit. So I think that it's unclear where all of that goes as a legal matter. I don't, as I said earlier, I don't think sort of the fear of the Supreme Court kind of reinvigorating Lochner-esque or, anti-worker First Amendment arguments or due process arguments or property rights arguments, all of which it may well do, should inhibit efforts at change.
Anna brings up just cause bills, saying they are very popular with voters, even in battleground states, and would so benefit undocumented workers. I'll note that New York City's fast food just cause bill was subject to a preemption challenge from the restaurant industry that so far was unsuccessful. In that case, the industry argued in part that just cause is something that people mainly get through unionization, and noted that the bill's sponsor had talked about it as a way to get people something they otherwise could have gotten through unionization, and argued that that was enough to make it preempted under federal law, and that argument was rejected. Is there anything any of our panelists would like to say further about that issue or ones like it?
I'll just add in terms of that case, the other thing that the restaurant industry and the chamber, the business groups argued was that legislation that was specific to one industry should be preempted because that's more like bargaining. And the district court also rejected that argument, which is particularly important for some of the other initiatives that we've been talking about. My understanding is that there is an effort, a percolating effort in New York to expand the just cause legislation. We also see efforts in Illinois. There's definitely growing interest in just cause legislation. There's also significant opposition from business. So as much as it's popular with voters, the opposition, the legislative hurdles are really significant.
We have about 8 minutes left, so still time for people to weigh in with questions. Senator Ramos, Kate, Mary Joyce, do any of you want to respond to anything each other have said so far?
I'll weigh in on a few things. One is I do want to look into just cause bills and what that would look like statewide in New York. I haven't looked into that yet. But also to kind of piggyback on Kate in her previous intervention, I have introduced a bill in New York State to raise the minimum wage, but not just to raise the minimum wage, but to actually peg it to inflation, so that we don't have to have this tedious and this tedious conversation that very often leads to lies from the business community, from the big business community, and prevents workers from actually being able to afford to support their families and hopefully a little more. And that's something that is going to be the #1 priority for me next session, because the cost of living here in New York, I mean, here we like to say that the rent is too damn high. And it's true. The cost of living here in New York is increasingly difficult for working class families. And we all know, we're all here because we know that the labor movement and unionization is the path to the middle class. But it's quite unconscionable that some other big cities, for example, San Francisco, will very soon have a higher minimum wage than we do here in New York, unless we take action very, very soon. And that's how our folks get displaced. I mean, I don't need to tell you about New York State and especially New York City real estate and the grasp that they have not only on many of my colleagues who continue to take their donations, but over the legislative process overall. So that's what we're up against. But I am increasingly inspired by just how many workers in New York and around the country are organizing. And hopefully that will help us create the political will and the noise that we need to get this minimum wage increase, and most importantly, indexing it to across the finish line.
I'll ask about wage and standards boards, which I think each of you have brought up in some way. As was noted, part of what theoretically makes these setups not preempted is that they are not collective bargaining between two parties that directly set standards that are legally binding. There is a tripartite structure in a sense, in that industry and labor are conferring on potential standards, and then the government still has a role in actually enacting recommended standards. Some people might say this is kind of a Rube Goldberg machine that may not be worth it when you have the alternative of labor just lobbying directly for a just cause law or for a safety requirement or for a raise or whatever else. So I wonder if there's something any of you would like to say about what it is that makes it worthwhile to create this ongoing standards board in that context.
Well, I think I'm going to speak to this. I think there is a value in, particularly in industries where there is a lot of antagonism. There's very little opportunity for the industry and the workers to come together. In fact, there's just, in the industries I'm thinking about, there's an avoidance, even when invited in other settings to come and try to solve a problem that's a big problem. The industry is not interested in doing that. And so I think there is a value in, in co-determination, I guess, if you would say, or as a beginning step, beginning to work together to solve some workplace problems. And of course, in other countries, like I'm thinking about Germany, where the minimum wage is set in Germany in the restaurant industry, like this. And it certainly doesn't prohibit unionization. And probably, in fact, I know when the fast food workers union in Germany was invited to participate in that body in Germany, it probably actually aided their efforts at unionization. So that's one thing. And I want to go back though to the thing that Kate raised about the minimum wage, because miracle of miracles, we were successful with a ballot initiative in Florida, and there are very few states where the ballot initiative is a vehicle that can be used to raise the minimum wage. Mississippi, interestingly enough, is another one, although there's some contention there right now about what can happen on ballots and what can't happen on ballots. But the other issue that we need to figure out, and I don't think just cause is the way to go on this, is that in all of these red states, there are blue cities. So in Georgia, for example, Atlanta is a blue city. It's also a predominantly African-American city. Augusta is a blue city. Savannah is a blue city. And so there's a real issue about and of course there's huge numbers of workers in the non-agricultural setting that work in those cities, primarily in the service industries. And so there is an issue. What can we do in these blue cities? Charleston is a blue city in South Carolina. Columbia is a blue city in South Carolina. In Mississippi, Jackson is a blue city. And, we tried very hard in Alabama. Birmingham is a blue city. And the mayor there wanted to raise the wages. And we tried very hard, and he was preempted immediately after he passed a wage increase. But I do think part of what we have to figure out politically and for the workers is what can we do in these blue cities that will hold up, that will advantage the workers in those places. And I don't know, maybe that was a topic at another LERA meeting, but it's certainly an important one, and the answer has not been forthcoming yet. Anyway, I wanted to make that point, Josh, those 2 points about the ballots and about the blue cities.
Thank you so much. And thank you to everyone. Senator Ramos or Kate, do either of you have 30 seconds you'd like to say as we close?
Sure, very quickly, I mean, I'm a senator from a blue city, but certainly there are many Republicans here in New York, especially upstate, some on Long Island. And I just want to say that we shouldn't give up on talking to them, actually. And this is something that stayed with me from that Trump-Clinton election, is that many workers who ended up voting for Trump were very much willing to vote for Bernie Sanders, because both of these candidates spoke to their economic realities, and fortunately, of course, the one who became president was not exactly accurate about them necessarily, but there is a void to fill, I think, in speaking to workers about their economic interests. It's something that the Working Families Party used to do here in New York. Unfortunately, it's become much more aligned with the DSA here. And I think that has ostracized many other people who might be turned off by more ideological specific leanings, and are much more interested in engaging around the issues that they're dealing with in their everyday lives. And I don't think that we can lose that connection to workers. I miss having a Labor Party. I remember the WFP when it was a Labor Party here in New York, and I miss those days dearly. That is exactly where I'm hoping that we can return, so that we can get all workers, regardless of how they might identify politically, to actually mobilize and support many of the initiatives that we're proposing, because they truly should be bipartisan efforts. With the Amazon warehouse workers bill, the most dangerous warehouse in New York State is on Staten Island, where the Amazon labor union was formed. The senator there is a Republican, Senator Lanza, and he refused to co-sponsor, much less vote for the bill, which to me is a travesty, but he gets away with it, right? And so those are the things, at least on the state level, that we're thinking about.
Thank you. We are preempted from continuing the conversation further, but thanks so much again to everyone. Please, anyone in this conversation, I personally am eager to hear from you about tips about stories, ideas about stories, thoughts about all of this. I've shared my email in the chat, and I'm grateful to the audience, to our panelists, to LERA. Thank you very much. More to discuss next year.